You find indeed, isn't it, everyone? I've improved presentation chart. Does it look fine? It is far better than the previous one. I expect more vision for each of you. Please note that the class could be far less exhaustive than regular ones of constitutional law. As we pursue the basics of common law, as accorded with the title of this class, we have no way but to survey only typicals of a U.S. Constitution. The class discussion on this subject will seem to be continued until the last of next week. I prepared pages to cover cases and comments explored in this class. Can you move up to pick up those? Yeah. Please take a brief tour through the printouts in front of this lecture. Okay, it is perfect. We now begin with the due process of law analysis. The Constitution is normally viewed to operate as a bulwark of people's fundamental rights. The Bill of Rights actually has a long history to date back to 12th or 13th Magna Carta. It constitutes a core concept to militate against an abusive state power as well as an ancient regime. The concept symbolizes the rise of civil democratic society, although its primitive definition largely involves the fundamental liberty of noble class against an absolutism of a monarch. The Bill of Rights, a more popular basis, was actually achieved during the French Revolution, the consequence of which produced the Universal Declaration of Human Rights. The concept of fundamental rights now be arrogant not only in the domestic context, but also was strongly proposed by the United Nations. We know that the concept also provides many of our diplomatic ground to foster or sanction other foreign states. In the context of a United States Constitution, the case law recognizes twofold of due process analysis. One would be a procedural one, while the other involves the substantive due process right. The concept would find its constitutional ground on the post-Civil War amendments, including the 13th, 14th, and 15th Amendments. Through the introduction and cases in the printout, we will be instructed about this area of law. Please have an awareness that the procedural due process triggers the traditional form of due process concept, which could be concerned of fundamental rights in a state procedural justice. In contrast, the substantive due process would focus on a substantive law, depriving the liberty and property interest of people. Let's see the procedural due process in the United States Constitution. The Bill of Rights was added to the federal Constitution to provide additional protection of both individual and state rights. Originally, the Bill of Rights limited only the power of the federal government. Most state constitutions contain their own version of a Bill of Rights. Through the 14th Amendment, however, the Bill of Rights has been applied to state action. This chapter we see, therefore, a due process requirements over a criminal procedure or abortion and other economic regulations and so forth. Before the Civil War, there had been limits on governmental power. The basic constitution mainly established the structure of government, but it also prohibited state and federal ex post facto laws and bills of attainder. The Privileges and Immunities Clause also provided protection for state citizens. As mentioned above, the addition of the Bill of Rights added no further protection against state action. This position was confirmed in the notorious case, a Barron versus Mayor of Baltimore, decided in 1833. We have a brief fact pattern of this case. And the printout in the page, can you identify the page number in the printout? I'm not sure. The first page of the printout delivered in this class. Let's see. Barron sued the mayor and city council of Baltimore, was this, for permitting street construction that had the effect of depositing silt in front of his work, making it inaccessible. P obtained a verdict for $45,000 that was reversed by the state court. P appeals on grounds that his property was not granted proper protection under the Fifth Amendment. The Fifth Amendment provides a just compensation for a taking of a government. Then we have to consider if the Bill of Rights, of course, citizens of the United States protection from state government acts, the court was in a negative position, and the case was dismissed. According to the court opinion, the limitations on government power expressed in the federal Constitution are applicable only to the government created by that instrument. The United States Constitution is a federal document, even though it is supreme law of land. Had the farmers intended them to be limitations on the powers of the state governments, they would have expressed that intention. Any limits on state powers can be found only in the respective state constitutions. For this reason, the court has no jurisdiction and must dismiss the case. Although the court already presumed that the Bill of Rights did not apply to the states, it could have inferred otherwise from the fact that all the Bill of Rights provisions are cast in general terms except the first, which specifically applies only to Congress. After the Civil War, the 13th, 14th, and 15th Amendments were added to the Constitution. Each gave Congress power to enforce its provisions through legislation. In the 13th Amendment, which was adopted in 1865, forbids slavery and involuntary servitude and provided a constitutional basis for President Lincoln's Emancipation Proclamation. On the ground of a 14th Amendment, adopted in 1868, the Congress could have a constitutional basis for the Civil Rights Act, but by its terms went much further than the problems of slavery and race. Actually, the Civil Rights Act was promulgated in 1866, 2 years earlier than the adoption of the 14th Amendment. Later, the amendment provided a constitutional ground for that Civil Rights Act. And the 15th Amendment dealt with the right to vote. There was no suffrage system for the black Americans and female persons in the United States at that time. So the Congress enacted the Civil Rights. The Constitution was added, the 15th Amendment, which was enacted in 1870. It prohibited restrictions on the right to vote based on racial grounds. But the Supreme Court showed the attitudes to exercise a narrow interpretation of the amendments, which was manifest in the case, the Slaughterhouse, named the Slaughterhouse cases, which was decided in 1873. Let's see the facts of this case. A group of New Orleans butchers, was the plaintiff in this case, challenged the state law granting a state corporation the exclusive right to operate facilities in New Orleans for the landing, keeping, and slaughter of livestock. His only means of practicing their trade was to pay fees to the state corporation and work at the corporation's plant. The state courts upheld the statute. Peers appeal based on the following constitutional objections. First, the statute creates an involuntary servitude forbidden by the 13th Amendment. And second, it abuses the privileges and immunities of citizens of the United States. And third, it denies peers the equal protection of the laws. And fourth, it deprives them of their property without due process of law, all in a violation of the 14th Amendment. The court faced the issue: if the Civil War amendments grant United States citizens a broad protection from the actions of state governments, the court said no. The lower court judgment was affirmed. According to the court opinion, interpretation of the meaning of the Civil War amendments must reflect the historical setting. Therefore, the meaning of involuntary servitude in the 13th Amendment is restricted to personal servitude, not a servitude attached to property as P claimed. The 14th Amendment clearly distinguished between the citizenship of the states and citizenship of the United States. Only those privileges and immunities of United States citizens are protected by the 14th Amendment. Privileges and immunities of state citizens upon which peers rely here are unaffected and rest for their security and protection in the power of the several states as recognized in Article 4. The Constitution does not control the power of the state governments over the rights of their own citizens except to require that the state grant equal rights to its own citizens and citizens of other states within its jurisdiction. Therefore, peers have no privilege or immunity as citizens of the United States that is infringed by the state law. The Equal Protection Clause of the 14th Amendment was intended primarily to prevent state discrimination against blacks, although the Congress may extend its scope to other areas. But peers have claimed the denial of equal justice in the state courts and therefore have no reason to have a remedy under the Equal Protection Clause. The restraint imposed by Louisiana upon the exercise of peace trade simply cannot be held, consistent with prior interpretations to be a deprivation of property within the meaning of that provision. We have several dissenting opinions from Justice Phil Swain, Bradley Chase, and also Justice Bradley. This implies that the decision was rendered in an intense debate among the judges. The majority's view of privileges and immunities has prevailed to date, so that it protects a few rights of national citizenship, but not state citizenship. These include the right to travel among the states, to vote for national offices, to petition Congress, and to enter public lands. The rights asserted by the dissenters in this case have come to be protected by the due process and equal protection clauses. And the procedural due process would be much more meaningful in terms of the criminal procedure. And around the issue, we have two basic viewpoints, which come within what I call the incorporation doctrine and a fundamental principles of liberty. The first view is a more expansive in applying the procedural due process concept, while the latter, what I call the fundamental principles of liberty, would be restrictive about the scope of an application. Whether or not the 14th Amendment due process clause incorporated the rights guaranteed at the federal level by the Bill of Rights and made them applicable to the states was an important question. Some commentators and judges argued for total incorporation. In other words, the Bill of Rights should apply fully to state action. Others argued that due process included only fundamental principles of liberty. And we have a very helpful passage from the court opinion to facilitate our understanding of the meaning of due process. It was from the case titled Hurtado versus California, decided in 1884. Any legal proceeding enforced by public authority, sanctioned by age, or newly devised in furtherance of the general public good, which regards and preserves principles of liberty and justice, must be held to be a due process of law. When it confer on the procedural due process concept, we have to look into a fairness of a arranged procedure in the context of the raised dispute. About the fundamental fairness, we can see some of lessons from the case Parker versus Connecticut, decided in 1937. Parker was tried for murder. The jury in the state court could find him guilty of second-degree murder, and he was sentenced to life in prison. The state appealed, and the state Supreme Court reversed the trial court for errors of law. They were tried again, and this time sentenced to death. He argues that he has been subjected to double jeopardy, and appeals claiming that the first judgment has to be invalidated. The court faced the issue if the Fifth Amendment if the Fifth Amendment prohibition against double jeopardy applies to states through the 14th Amendment. Therefore, the scope of the 14th Amendment was raised as an important issue to dispose this case. The court said no, and the lower court judgment affirmed. The Fifth Amendment would forbid such an appeal by the United States government in a federal case, but in the cases establishing this rule, reasonable minds have a deferred. Some have sought double jeopardy to mean even less than this. What the state has done, therefore, is not repugnant to the conscience of man, and therefore does not violate the 14th Amendment, which does not cover everything in the Bill of Rights anyway. There are two classes of rights, according to the court opinion: fundamental principles of liberty and not so fundamental rights. The concept of due process includes the former, but not the latter. Examples of fundamental principles include those that are implicit in the concept of a ordered liberty, those that, if violated, would shock the conscience of mankind, and those that are part of fundamental fairness and rooted in the traditions of man. And this is a pioneering case about the scope of a 14th Amendment, but it is far narrower than the attitudes of court in this contemporary times. And later, a very legitimate argument for total incorporation was raised in many of cases. Notoriously, we can find Adams versus California, decided in 1947. The court decided the due process did not require reversal of a state criminal conviction, where the prosecution had commented on the defendant's refusal to testify, although such a command would be reversible later at the federal level because of the Fifth Amendment. Justice Black and Douglas dissented. arguing that the original purpose of the 14th Amendment was to incorporate fully all of the Bill of Rights guarantees. They argued the failure to incorporate those specific guarantees would leave citizens without assured rights and would at the same time grant the court an unauthorized broad power to expand or contract the scope of a due process virtually at will. They also indicated a preference for selective incorporation over no incorporation at all. And the rise of this kind of a minority opinion will later be realized as a official court position. But we have to note there will not be a form status about selective incorporation or total incorporation, although the court agreed on some of a incorporation framework. As indicated above, the Supreme Court has taken the position that the provisions of the Bill of Rights apply to the states just as they do to the federal government. For example, the Fifth Amendment provisions concerning the privilege against self-incrimination and double jeopardy, and the Eighth Amendment provision against a cruel and unusual punishment have been held to apply to the states. But with the court increasingly looking to the Bill of Rights and incorporating its provisions through the 14th Amendment in application to the states, it may be the selective incorporation may have proceeded to the point where it is essentially a total incorporation. Concerning the procedural due process concept, we have one other case about a trial by jury. As you know, the United States adopted a jury trial over many civil and criminal cases, and it mattered with the concept a procedural due process. Most famous case would be a Duncan versus Louisiana, decided in 1968. Duncan, who as a defendant in this case, was convicted of simple battery, a misdemeanor in Louisiana, punishable by up to 2 years imprisonment and a $300 fine. He was fined $150 and sentenced to serve 6 days. He was refused a trial by jury under Louisiana law, which he then challenged it. But the state Supreme Court refused to review the appeals. The court has to answer if a state that provides trial by jury for all felonies may try charges of simple battery to the court alone. The appellate court said no. The Supreme Court of the United States said no. A judgment reversed and the case was remanded. The Supreme Court stated that the right of trial by jury in serious criminal cases is fundamental to the American scheme of justice and qualifies for protection under the Due Process Clause against violation by the states. The authorized penalty is a of major relevance in determining whether a particular crime is serious. The possibility of 2 years imprisonment clearly indicates a serious offense, so it is within a due process protection. The Sixth Amendment guarantee of right to jury trial is hereby applicable through the 14th Amendment to state criminal cases, which, if tried in a federal court, would be covered. Where two sets of concurring opinions, but on other constitutional and statutory grounds, filed by Justice Bragg and Douglas, and also by Justice Fortas. And now we have to turn to the substantive due process problem. We have briefed the introductory part of a substantive due process in the previous class. We now get further on economic regulations and abortion or other familiar rights. Let's see. The statute about a maximum hours labor would be questioned in the court proceeding. The court upheld a law fixing maximum work hours for women, distinguished Lochner by the special state interest in healthy women. The case was Murrah versus Oregon in 1908. However, the court later effectively overruled Lochner by upholding a general maximum work hour law in Bunting versus Oregon in 1917. However, the court did not refer to Lochner, and substantive due process survived. The federal government had a regulation about yellow dog contract. The court invalidated the state law that prohibited employers from requiring employees to agree not to join a labor union. This unfair contract would normally be called a yellow dog contract. You may have heard of it in the civil law classes in this law school. The law violated due process because it interfered with the right to make contracts. The court in AK.EDU versus United States in 1908 invalidated a similar federal law. The regulation might be on a minimum wages issue. The court invalidated a federal minimum wage law applicable only to the District of Columbia in Atkins versus Children's Hospital, decided in 1923. Again, finding that interference with freedom contract violated due process. And the economic issue may be about a business entry and regulations. In a series of decisions that have been undermined by developments since the 30s, the court invalidated restraints on competition that curtailed entry into a particular type of businesses. You can see in New York State Ice Corporation versus Lehman, decided in 1932. manufacture of ice requiring a certificate of a convenience and necessity. And in Adams versus Tanner in 1927, the court held employment agents' fees collected from workers had to be invalidated. The court illuminated a means scrutiny in Weaver versus Perma Brothers, decided in 1926. But the court recognized the validity of the state interest in curtailing business practices that might defraud or endanger consumers. Eventually, the court invalidated an absolute ban on the use of shoddy fabrics for bedding. The court held that the ban was purely arbitrary, since other second-hand materials could be used if sterilized and labeled. There were a travel of a case law in this area around around the start of new century through the 30s. In modern era, the court was relatively reluctant to intervene in economic regulation. They tend to show a difference to a congressional action about economic matters. Sometime after Lochner, the court changed its earlier view and began to apply less strict scrutiny to economic regulation. Instead, it granted a deference to legislative determination of need and reasonableness. In Nevia versus New York, decided in 1934, New York passed a law establishing a minimum and maximum retail prices for milk. The purpose was to aid the dairy industry, which was in a desperate situation because the prices received by the farmers for milk were below the cost of production. Nevier, a retail grocer, sold milk below the minimum price and was convicted for violating the statute. They challenged the statute as a violation of due process. Then you have to think, if a state may strictly control retail prices, even where such control inhibits the use of a private property and the making of contract, it should be said yes. And the lower court judgment was affirmed. As long as the court finds the law to have a reasonable relationship to a proper legislative purpose, to be not arbitrary or discriminatory, and the means chosen that are reasonably related to the end sought, due process is not offended. No area is outside the province of a state regulation for police power purposes, including the direct regulation of prices. And we have other cases on minimum wages, titled West Coast Hotel Company versus Paris in 1937. And you can find a further retreat from Lochner in United States versus Current Products Company in 1935. The court confirmed that Congress can prohibit interstate shipment of a food products that it deems injurious to the public health. And they are given almost unlimited latitude in enacting economic legislation for such purposes and ends as they see fit. Therefore, the court upheld fixed a maximum employment agents fees and a permitted restrictive regulation of the business of debt adjusting. A business of debt adjusting. And the court also upheld a law requiring employers to give employees paid time off for a boarding. When we come on the substantive due process issue, one of other important consideration has to be given to the taking regulation. Whether the governmental action could be classed as one type of regulation would be critical, because the action should accompany compensation if it is considered to be taking in a constitutional purpose. Actually, there is no specific power of eminent domain in the federal government. Rather, it is an implied power. Also, the power of eminent domain may be exercised pursuant to the necessary and proper clause whenever Congress is acting in accordance with one of its other specific powers. There is an express constitutional limitation on the exercise by Congress of this power. The Fifth Amendment states, "Nor shall private property be taken for public use without just compensation." The requirement that just compensation be paid is likewise a constitutional limitation incorporated into the 14th Amendment and applied to the states. Despite this limitation, under the police power and other regulated powers, a government may impose restrictions on property that produce substantial diminution in value without having to compensate for losses incidental to these valid regulations. The question is, what is taking and what is merely a regulation? We see the requirements for the exercise of eminent domain. The concept of public use affects to find the eminent domain have a requisite constitutional ground. The use for which the land is taken must be a public one. The notion is a broad one, since the courts are willing to allow government to do pretty much what it wants to if it will pay for it. If the exercise of the power results in a public benefit, the government can delegate the power of eminent domain to private companies, educational institutions, government agents, and so forth. And the exercise of eminent domain has to suffice the necessity requirement. The necessity question is now reviewable in federal condemnation cases. That is, the question of whether it was necessary or desirable to take plaintiff's land will not be reviewed. Many jurisdictions will not review the question of necessity also. Other jurisdictions hold that the question is justiciable in some instances and not in others. In those days, they permit a limited review. Such review is normally limited to question of whether there has been excessive taking. And the third element would be a just compensation. Just compensation has usually been held to mean fair market value at the time and place of the taking. This price must be paid in cash. The test is the loss to the owner, not the gain to the taker. Most notorious case about this area of law would be a First English Evangelical Lutheran Church of Glendale versus County of Los Angeles, decided in 1987. In this case, the court had to answer if a landowner may obtain damages for government taking of his or property before it is finally determined that the regulation constitutes a taking of the property in the 5th and 14th Amendments. The court sustained a landowner position, and the lower court judgment was reversed. The 5th Amendment does not prohibit the taking of a private property, but requires the government to pay compensation for such a taking. If a government action works a taking, the government has a constitutional obligation to pay just compensation. The inverse condemnation action reflects the self-executing character of the 5th Amendment. This rule that the government must compensate for temporal takings does not limit government flexibility. The government can still decide to terminate the taking. And in subsequent cases of a Penn Central Transportation Company versus New York, decided in 1978, and Nolan versus California Coastal Commission, decided in 1987. The court developed a theory about a constitutional interpretation around the taking and regulation issues. For example, the court said a city may restrict development of individual historic landmarks without a taking, requiring payment of just compensation. And the court also confirmed the state may not require the conveyance as a condition to its approval of land use permit for land use permit for the property. If a state may not require uncompensated conveyance of an easement of a private property. You can see in chart 1 a taking versus regulation. I've classed some cases of government action in a categorical way. And I've employed the court opinion to characterize its status. First, the condemnation of land to build highway. The court considered it a taking, which means the state, the government is required to pay a just compensation. And second, creating a public access, it would consider taking. Abolishing inheritance rights, it will be taking according to the court position. It is a standing law to govern all the governmental actions in this contemporary times. Fourth, a zoning ordinances that merely prohibit the most beneficial use of property. It could not suffice a taking requirement. It would be viewed as just a regulatory measure. Fifth, ordering destruction of diseased trees. It would be a regulation in court terms. And landmark ordinance would usually be considered a regulation. And in chart 2, you can see some essence about a type of process required to suffice the procedural due process provision. As to the interest involved, the process required would be a different in a scope or a way of handling the issue. For example, the issue may be a commitment to mental institution. Is it a serious issue? The court required this scope of process. For others, a prior notice is indispensable, and also as coupled with prior evidentiary hearing. But in emergency situation, prior evidentiary hearing would be waived. That could suffice the constitutional test. If this scope of process would not be offered, then the action about a commitment to mental institution would be rendered unconstitutional. For the case of children, prior screening by neutral fact finder would be necessary. A parental consent alone is insufficient. This position was confirmed in a case law. And there would be an interest about welfare benefits. For example, the government may deprive the welfare benefits without any prior notice. It would be constitutional. Into welfare benefits, it is a settled of law that the prior notice and providential hearing is required. About a disability benefits, the court required a prior notice and opportunity to respond, as well as subsequent evidentiary hearing would follow to suffice the constitutional requirement. And let's think about employment. There would be a tenured professor or other public offices in not a settled status. They might be fired for some reasons, but with some of a process about the counter-argument or any other evidentiary presentation. In this case, the court generally would require a prior notice, an opportunity to respond, and subsequent evidentiary hearing. It might not be as stern as a formal court proceeding, but very similar extent of a process has to be provided to protect the rights of a professor or public employees with a presentation of evidence and pertinent argument and so forth. There was a case involving a public education. Let's think about a student of a public high school or a public university. There might be a disciplinary suspension or academic dismissal. This kind of issue has to be debated through the process having a prior notice and opportunity to respond. No formal evidentiary hearing is required. How about a driver's license suspension? A prior evidentiary hearing would suffice in this case, but there would be some of exceptions surrounding a breathalyzer test suspension statute. Many of states have this kind of a statute about breathalyzer test. There would be many of the alcoholic drivers in the state, and it is critical to counter that kind of a dilemma. And we may consider a termination of parents' custody rights. In this case, a prior notice and prior evidentiary hearing has to be offered to suffice the constitutional requirement. And the interest involved would be a civil forfeiture. In this case, prior notice and evidentiary hearing for real property a subsequent notice and hearing for personal property. The court opinion split about the nature of the property at issue. Normally, a more official way of a process has to be offered when the property would be classed as a real property. And now we continue on some other areas of a substantive due process issue. The court have long reserved the cases involving a familial rights a personal appearance, and other private matters. Typically, abortion and contraception and gay rights or others would be raised a frequent subject in this area of law. About an abortion, most notorious case would be a Roe v. Wade decided in 1973. Roe, with plaintiff in this case, married and pregnant. So a declaratory and injunctive relief against Wade, who is defendant in the case, county district attorney, to prevent enforcement of Texas criminal abortion statute. The district court invalidated the statute, and the Supreme Court granted review. Then the court has to answer if a state may constitutionally make it a crime to procure an abortion expert to save the mother's life. You have to note that there would be a conflicting constitutional interests around this issue, namely the life interest of a fetus and the privacy interest of the parents. Particularly, the privacy interest would be far weightier to the matter of a fetus. P claims a constitutional right to terminate a pregnancy based on the 14th Amendment concept of a personal liberty, the Bill of Rights penumbras, and the 9th Amendment. D claimed the state interest in regulating medical procedures to ensure patient safety and in protecting a prenatal life. The right of privacy generally relates to marriage, procreation, and contraception, and includes the abortion decision. But it is not without a restraint based on the state's compelling interest. The state's interest is prenatal life, cannot be based on the fetus' right to life. For a fetus cannot be considered a person in the constitutional sense. Unborn children have never been recognized in any area of the law as persons in the whole sense. However, the pregnant woman cannot be isolated in her privacy. The state may decide that at some point in time, another interest, that of health of the mother or that of potential human life becomes significantly involved. The woman's right of privacy must be measured accordingly. The state's interest in the health of the mother becomes compelling at approximately the end of the first trimester, prior to which mortality in abortion is less than mortality in normal childbirth. Only from this point forward may the state regulate the abortion procedure as needed to preserve and protect a maternal health. The state interest in a potential life becomes compelling of viability. A state interest in protecting fetal life after a viability may prescribe abortion except when necessary to preserve the life or health of the mother. The Texas statute challenged here is overbroad and cannot be upheld. We have reviewed a gist of a majority opinion. This position would be changed in some way in the later cases. For example, Doe versus Bolton, and Sundberg versus American College of Obstetricians and Gynecologists, decided in 1986. In Planned Parenthood versus Danforth, decided in 1976, the court held that the woman's decision whether to terminate a pregnancy within her constitutionally protected right of privacy and cannot be made subject to a parental or spousal consent. However, it did uphold a requirement that the woman give a written informed consent to the abortion and that she be of a certain age or maturity in order to consent. Also, in Bellotti versus Baird in 1979, the court invalidated a provision that required parental consent but permitted authorization of the abortion by a state judge for good cause shown. In H.L. versus Mason in 1981, the court upheld a parental notice requirement to protect family integrity and the emancipated minors it was directed toward. And later in 1983, the court exercised a strict review of regulation of abortions. In the case titled Akron versus Akron Center for Reproductive Health Incorporation. In this case, the court decided a state regulation of abortion must comply with prevailing medical practice and not diminish the availability of abortions without promoting important health benefits. Around the abortion issue, there would be some other context involving the government funding. Despite its strict scrutiny of regulation of abortion, the court has held that the government may choose not to fund abortions. In Mayer versus Law, decided in 1977, the court first dealt with this kind of question, and it is one of a major cases about this issue. The state had excluded non-therapeutic abortions from its Medicare-funded program, although it did cover childbirth. The court applied the rationality standard of review instead of a strict scrutiny. The court held the Law versus Wade did not preclude the states from favoring childbirth over abortion, so long as they did not unduly interfere with the woman's freedom to choose an abortion. The dissent argued that the exclusion effectively forced indigent women to bear children instead of procuring a desired abortion. And in Bill versus Doe of 1977 and Porker versus Doe in 1977 also, the court applied the same rationale to other programs. And there also would be a public funding of medically necessary abortions. The issue of which was raised in the case of Harris versus Magley, decided in 1980. In this case, the court confirmed the Congress may, consistent with the due process clause, deny public funding for certain medically necessary abortions while funding substantially all other medical costs, including cost of carrying pregnancy to term. And you can find that the abortion issue involves a very intricate nature in practical matters. According to the current court position, I have summarized the pre-viability abortion regulation in Chart 3. If there is no undue burden, the law requires doctor to give a woman relevant information to make implied consent. And the law also requires 24-hour waiting period. And the law requires parental consent or parental notice in order for minors to obtain an abortion if there is a judicial bypass option. The law also requires that abortion be performed only by licensed physicians. These elements have to be present to legalize the abortion. And there might be an undue burden about the abortion. Then the law requires the woman to notify a spouse about abortion. And the law bars all partial birth abortions. We have this summary of rule about abortion issue until now. But the court position might be subject to the change of circumstances on a case-by-case basis. We now explore the basics of equal protection problems in United States Constitution. The 14th Amendment ensures an equal protection of law for the people that binds the federal government. The obligation would be effectively imposed to the state government by way of operation of other constitutional clauses. The issue of equal protection would perhaps be most notorious one in the vast of constitutional governments around the world. As you read the laws of Korean Constitution, you can better note that the equal protection of law is most frequently raised to dispose the case at bar. It is rather divine in its origin that could be versed, all men are equal under the God. That belief probably would be translated as all men are equal under the laws. While the law replaces the status of God in modern secular society. Other verbs would also be familiar with the students. Equal must be treated equal, different for different. However, the issue has been no longer plain as the word indicates. Rather, this area of law involves an intricate approach on the evolution of legal theory. The Supreme Court has devised some of crucial terms to deal with the questions. It relies on a different extent of scrutiny depending on the nature of a discrimination. We have a rational basis test, a strict scrutiny test, an intermediate one. The court also uses the term of a suspect classification if the issue involves a keen area of public attitudes, justifying a suspicion of discrimination on its face. Also, when we survey the affirmative action, the destiny of which will still not be settled in the case law. It is sometimes called to be a reverse discrimination to remedy the past discrimination practices of state and society. That concept would in some sense be related with the substantial justice of equality beyond the plain dictate of an equal opportunity. The latter concept would be more extensive as to legitimate an equal treatment in favor of a deprived people without any specific reason. We now have the summary of key cases and its implications. Then we epitomize the essence of rules through the chart. It is a tricky area that could sometimes overlap between the substantive due process and equal protection questions. You can see some distinction between two concepts in this chart. You can see due process, which means which includes the process that regulation affects everyone. In due process consideration, you have to know the regulation affects everyone. In contrast, when we deliberate the equal protection issue, you have to know the regulation affects certain person or class of people. And in due process, there would be no fundamental rights involved. And in that case, a rational basis test would be applied. And the test would be if the law is rationally related to a legitimate government purpose. And the burden of proof would fall on the challenger of that issue. And if a fundamental rights are involved in a due process dispute, including privacy, interstate travel, voting, a First Amendment, then the strict scrutiny test should be applied. The standard test would be a little different, as the law necessary to achieve a compelling government purpose. The burden of proof would be imposed on the government. And in terms of equal protection, there would be a case involving a fundamental rights. Then a strict scrutiny test would apply. There might be some cases involving a suspect classification, including race, a national origin, and sometimes alienage. Then also does the strict scrutiny test apply to the case of power? When the case involves the equal protection issue, the subject would be on gender or a legitimacy, which would be considered as a quasi-suspect classification in the judicial terms. Then the standard of scrutiny would be an intermediate one. So we have tests. Is the law substantially related to an important government purpose? If the equal protection issue involves no suspect or quasi-suspect class and no fundamental rights, then it is plain to apply a rational basis test, which is lowest one in the standard of a court scrutiny. In next class, I would like to substantiate the list of issues involving equal protection. And it would be left for the next task. And I would like to further on a state action theory. This is a unique theory that could only be found in the constitutional discourse. As a constitutional student, it is a touchstone in analyzing the scope of application, whether the harms or loss was incurred by the act, decree, order, or ordinance, disposition, and other forms of state action whatsoever. That is importantly so that the Constitution is a supreme, but law of a public aspect to apply to the legal relationships between the state of course including the United States and its citizens. It could be easy to consider the well-known distinction between the public and private law. Your fundamental rights could be only proposed to counter the allegedly unconstitutional governmental action. This means that you cannot directly invoke your fundamental rights against your boss or potential tortfeasors in the constitutional context. The area of a person's legal life outside the scope of a public nature would reside exclusively within each person's autonomy for his own fate, diligence, talent, and resources. They will normally be open to competition, contract cooperation, largely connected with the market concept. That area of our livings would be susceptible to other areas of different virtue. But it is not absolutely true in practical matters that only government has power to impede human rights. It is also true that in modern times, we may see many significant imbalances between private entities. They are envisaged as equal in theory and ideology, but they are not equal in the real context. The traditional premise of civilized private law would no longer be absolute if we consider the large firms or enterprises against the traditionally deprived persons or groups. It is not just the state or federal government that have social power to abridge the human rights. As combined with the circumstances, we have to mind that the Constitution is a great document to incorporate the value, morality, and public good of this society. Then we can embrace some of goodness, public good, through the private power, where the Constitutions can break into it for standardized morality. That may have some parallel in favor of socialized program, but we could find a need to erect the nexus between the constitutional document and private powers. They will evolve upon a legal theory of state action in the United States context, and we have learned a similar framework in continental legal system, including Republic of Korea.